Hello friends, Namaskar. Today I am going to discuss an important perspective concerning the medical examination consent in rape cases. As we know that in a rape case, the police used to call us for the purpose of interrogation and they used to say us that we should give consent for the medical examination. And do you know, in a rape case, the medical examination of the accused is also sine qua non. If you are not going to undergo for the medical examination, in that scenario, adverse inference could be against you. But sometimes the accused is not willing for the medical examination because in our country, multiple accused who are implicated in a false rape case are under belief that they are having the protection of Article 20 subclause 3 of Constitution of India. So we are going to discuss whether their mythology is true or not, whether they are thinking in lawful manner or not. For this, I request all of you to maintain the proper notebook along with a pen or pencil so that whatever I am going to narrate you could be the part of your record so that you may remove your confusion and confusions of others. Please be noted, on that point judgment is pronounced recently by Honorable Supreme Court of India. Judgment date is 10th of June 2024. Citation is Mr. X versus State of Karnataka. Now there might be a question in your mind. Why Mr. X? Is Mr. X is the name? I want to clarify that in a rape case, the identification of victim or accused is not permissible. That's why Mr. X, Mr. Y, Mr. Z is used to denote the scene. And that's why we are having the citation in the name pronounced as Mr. X versus State of Karnataka. Petition number is 7880/2024. In that case, the accused was implicated in a false rape case as claimed by accused. Inter alia moved before the Honorable High Court for a specific remedy and direction was given to the accused to cooperate with the investigation. And direction was also given to the concerned police not to take any coercive action. To be noted that not to take any coercive action means the police is under duty not to harass, humiliate the concerned accused, and even they cannot file the charge sheet without the prior permission of the Honorable Court or the court which has given the direction. Ultimately, the concerned police, as per the compliances protocol, issued a notice to the accused as per section 41A of CRPC. As we know that 41A CRPC is a bypass to section 41 of CRPC. Section 41 of CRPC emphasizes on the arrest in the cognizable offences, and 41A CRPC inter alia provide protection from the arrest. In 41A CRPC notice, it is submitted to accused that you are bound to give consent for the medical examination. But despite of that, the accused has shown no willingness. He avoided the compliances. But despite of that, regular steps had been taken by the police for the compliances. And ultimately, the concerned accused submitted the reply to the notice, which is called a representation or the memorandum. He submitted that he is having the fundamental right to protect himself from the self-incrimination which is part and parcel of Article 20 subclause 3 of Constitution of India. And ultimately, he has shown his non-willingness towards a medical examination consent. And finally, on the ground of non-cooperation on that point, the further remedies had been declined by Honorable High Court. Finally, the accused had approached before the Honorable Supreme Court for the remedies. Honorable Supreme Court, while considering all the scenarios, specified that non-willingness towards the medical examination is a serious concern, and apart from that, the concept of accused that it will infringe Article 20 subclause 3 of Constitution of India is wrong. the said scenario would not affect the same. In that case, the consent IO was directed to have the medical examination of the accused, and on point of cooperation, remedies are inclined. So now it is clear to us that in a rape case, even though it is false, medical examination is must. We cannot refuse for the same. Apart from that, there is a statutory protocol. If you are refusing, adverse inference can be against us, and apart from that, it will not infringe Article 20, Subclause 3 of Constitution of India. So I think that I am totally able to cause all of you to understand this subject in a very easy manner. See you in the next video. Till then, Jai Hind, Jai Bharat.